Good afternoon. The last of our programme sessions. I gather just Mr. Cowley along with Mr. Fraser for the council, and I see Ms. Kinderman for the council. Oh, Ms. Lancaster's with us as well, Mr. Little, Ms. Marr. Right. What I've called matter 6 actually covers a number of things. Points I picked up in the representations, put in the original matters in issues and questions, and these few seem to be the ones that generated a wish for people to talk about some aspects. Also, it gives an opportunity to go through one or two of the main mods. Now, the first one is policy 5 on general waste management facilities, and just going straight down to D and E of that. I'll come back to A, B, and C in a minute. My question throughout the plan was some of the policies had presumptions in them which really are better expressed in terms of criteria for compliance. The council have gone along with me on that, and there's a number of main modifications which do that switch. I'm happy with those, and that's in this case main mod 21. So unless there's any comments on main mod 21 in itself and the style of the policy, that's all we need to say about that. The other questions raised in the policy arise from the whole of the representations, not necessarily just Mr. Cowley. Whether the terms of policy 5 are appropriate with respect to the exceptional circumstances test for proposals outside the stated favoured areas. And whether policy 5 is too restrictive, including with regard to greenfield sites. And does it, with other policies, provide sufficient protection from the impact of waste development as distinct from other types of industrial development? As I say, all those flowed from the representations. Mr. Cowley, is there something you'd like to raise on those points or anything under policy 5, really?
Sorry, sir, thanks. My concern is really related to, I suppose, a carryover from yesterday in relation to what we discussed at Cheveley in relation to the waste supply issue and the waste treatment and landfill in the AONB. And as you require, I will make further representations on that.
Yes, please. Yes, anything which relates to the policy.
Thank you, sir. So, everybody, yesterday we considered Cheveley, and according to the plan, the site waste has to have waste inputs to achieve satisfactory restoration. We discussed, I think, the problems of waste arising, capacity, recycling, and conflict with progressive restoration. I do not agree that waste is required for restoration, but that is what the plan is in front of us specifies. And in that respect, I suppose it's a soundness point. On history in the area, landfill has delayed restoration. All the sites that have been permitted in the AONB, in this general location around Cheveley, none of them achieved the timetable. And I understand fully why that is. But one needs to be pragmatic about that and accept that problem and not try and say, oh, it won't arise. And for that reason, that's why there is a consideration here about whether there are exceptional circumstances to allow waste disposal in the AONB, considering that there is this ongoing problem about harm and continuing harm and lack of enhancement. So if we accept that landfilling in the inert waste isn't an exceptional circumstance in NPPF terms, then I think that has implications back onto the allocations for sand extraction. I know we discussed that partly yesterday, but it's implicit in the plan that Cheveley requires waste disposal to make it acceptable to the landowner. Now, whether that's a requirement for a public interest issue, I don't know. But now the plan has adopted that and accepted that as a requirement. If that cannot be achieved in satisfactory terms, then it undermines, I suggest, the whole basis of sand extraction. Because if the extraction site is going to be left in an unrestored state for a long time, there's a considerable problem there. So the site at Chieveley, therefore, suffers from what I regard as a deliverability problem, not a problem that hasn't actually been addressed by the authority, because there's a conflict between what the landowner wants and what is required under AONB policy. So we have, in that sense, a very significant showstopper, which is ignored by the authority. Now, my concerns to my clients is on the possible harm to their amenities and the AONB around them in the site at the 60-acre field site, which is not that far from Chieveley, and may follow because of inadequacies in Chieveley itself. The debate yesterday on the supply from Chieveley debated various figures, but it is absolutely clear that Chieveley will not meet what West Berkshire considers to be the demand over the planned period, and somehow or other sites or some other solution will be required. Now, that opens the door. I think what I said yesterday, that opens the door to further sand extraction from within the AONB. And that would arise even if Chieveley were deleted from the plan, or even if Chieveley as an application was subsequently unsuccessful. Now, the 60-acre site which adjoins my client's property is particularly vulnerable, therefore, to an application to make up for the deficit of Chieveley in whole or in part, and the deficit in whole or in part to the supply which West Berkshire considers required. And I think they need to consider that. Ms. Kinderman, when I asked about the point about windfall and policy 4, in relation to the failure of Chieveley, she said it wouldn't lead to any more further pressure on sites in the OMB, but I think that was rather dismissive of the problem, because the council has accepted there are exceptional circumstances because of need, and therefore there would be, to my mind, if one looks at the policy and the whole plan in itself, exactly the same scenario in relation to an application that would be made on the 60-acre site. Exceptional circumstances in the council's terms would exist because there is a need. Now, this would also raise an issue in that sense, because this would probably be a competitor's site, not least because even if Chieveley were to be granted consent, it would not provide a 7-year land bank for soft sand.
Mr. Cowley, I'm very, very sorry to interrupt you, Mr. Cowley. I'm sorry to interrupt you because I know that you're in the middle of your representations, but I may be wrong, but the purpose of this session was to cover policy 5. We considered Chieveley the allocation yesterday and all of the issues arising therein, and you made a number of representations which we responded to. We have nothing to say in response to any of these points because we've already dealt with them. If you have specific points you want to make about the wording of policy 5, then absolutely we can respond to them. But I may be wrong, so I might have got the wrong end of the stick as to what this session was about, but I thought it was about the wording.
It's about policy 5 and it's about waste management. There may be knock-on effects between policies, but actually you're quite right. We've dealt with policy 4, and Mr. Cowley is moving into policy 4. I mean,
apologies, sir.
Well,
I will stick to the waste management point of view.
Well, if there's anything you'd like to say to complete your comments, which does relate to the
very
question
quickly
under policy 5, I mean, there's the exceptional circumstances test. That brings the exceptional circumstances test of policy 5.
Yeah. I just raised the point that under the waste management situation, the exceptional circumstances test, it would appear that the authority has accepted that waste management by infilling in Chieveley is an exceptional circumstance. And that same situation would arise to any mineral working restoration opportunities in the AONB. And the primary concern of my clients is in relation to the site, the 60-acre site which adjoins their property. That's the fundamental point there, sir. Thank you.
Right, thank you. Well, Ms. Kinderman, whoever wishes to respond for the council.
I'll invite Ms. Kinderman in a moment, but just to make the obvious point, sir, that the exceptional circumstances is not to do with the waste management aspect, it's the extraction. And obviously, once you've done the extraction, you then have the restoration. So I don't think it's quite right for Mr. Cowley to be suggesting that we're relying on the infill to be and saying that there's some exceptional circumstances for that, because that's not the primary development here.
No, never.
Ms. Kinderman.
Thank you. Yes, just a point of clarification regarding this issue. And actually, I think it's possibly better considered under policy 7, because we are talking about infill, and policy 7 is landfill and the permanent deposit of waste to land. However, as it's been brought up, there is a difference between what's considered disposal, i.e. landfill, and recovery, which we consider to be the restoration of mineral sites. So we don't consider it would be landfill within the AONB. We consider it would be a recovery operation to restore the site to its former use. And that is, I will just provide a reference for your benefit. The joint position statement on the Southeast Waste Planning Advisory Group. I will just get the reference up. It's one of the CD006E. And the paragraph number is 2.2.4.10. And it discusses the difference between when an operation can be considered landfill and when it can be considered recovery. And it says, where the local plan provides for the backfilling of the mineral void for a specific after use and the development facilitates the same using the minimum volume of inert waste necessary, then it should be deemed to be recovery.
Yes, I think really most of what Mr. Cowley was saying does relate to concern over the prospects for respective sites to be worked. And he was in fact referring to what now is an emission site, if you put it that way. Well, not even an emission site, because I'm not aware of any representations specific to 60-acre site, only to the question of site selection. So I've noted that reference. My concerns over policy 5 were simply to cover any aspects of that policy which come up elsewhere in the written representations. And of course, there may be other points which I can go back to in writing. But unless there's anything further on policy 5 in terms of those questions from Mr. Cowley, then we can move on, actually. So policy 7.
Sir, could I just come back? Sorry, sir. Could I just come back? I note the point that Mr. Fraser says, but if restoration is an implicit back to a certain area is implicit, and that can only be achieved by importation of waste, then that does have an implication on the acceptability of the original extraction operation. In relation to Ms. Kinderman's point, recovery will allow a certain volume of material. It won't necessarily therefore achieve the restoration back to surface. It certainly wouldn't achieve what is proposed at Chieveley. You can only allow a certain amount of material under recovery license and that would not achieve what the restoration is required at Chieveley. But in any event, that still requires material to be imported into the site. And there are those questions about the volumes of waste arising and the suitability of them still apply and are still concerns. There are not enough materials to fill the voids that are required, even under just recovery license positions.
But all these points relate to what we've discussed before in terms of restoration, feasibility, etc., deliverability, all those things about the allocation in the plan. We've moved on from site allocations in the plan to the waste policies in terms of development management. So we needed to narrow the discussion down to that and what's relevant. So
thank you.
It seems to me that we're on policy 7, landfill. The questions which I picked up in the representation, I first read them, was does this policy make appropriate provision for landfill over old landfill sites is to maintain ground levels? That was a question raised. Frankly, I can't even remember who it was raised by. Then the second question for policy 7 was, shall we make it into a criterion policy? And to which the answer through MM25 is yes. And there's no argument about that. So are there any relevant questions about policy 7? Otherwise, is the question for the agenda. Because if not, we only need to look at policy 15, which refers to permanent aggregate infrastructure. B is about the style of the policy being changed to one of criterion compliance, which is in main mod 30. And the question was raised by somebody, should policy 15 be extended to cover permanent waste infrastructure? Policy 15 is the one which talks about location of permanent construction aggregate infrastructure. So the simple question was, well, should the same terms apply to waste infrastructure? I don't know if the council want to comment on that.
That's covered in our position statement, but essentially permanent waste infrastructure is just that, and it's dealt with under the waste policies.
If I'm honest, I've probably been remiss and not read that part of the opposition statement, but of course I can go back to it. And then there's the question of equine waste. Well, very polite term, clearly mostly dealt with locally, shall we say. MM24 missed it, sorry. MM24 is before. So need for planning permission to be granted for specialist waste, including facilities to manage agricultural and hazardous wastes where, etc. The point is, of course, that horsekeeping is not agriculture, or it can be regarded as agriculture when they're just grazing and so on. So it's a sensible precaution to put in equine to satisfy a representation which did seem to be concerned about the amount of equine waste around the district. I'm not aware of any other issues surrounding that. It was these items were originally included because there was an indication that people wish to speak on that matter. In fact, I think we've had a bit of a dropout rate. It does raise the question whether this afternoon session was really necessary at all, but we've come to the end of it now unless there's any further comments.
Not from the council, sir, no.
If there are no further comments, I just want to come to a few closing remarks. Closing in the sense of today's hearing. We don't close the examination, of course. Simply about how I mean to proceed and give you the best indication I can of how I mean to proceed. But as I've been saying, I've been given quite a bit to think about. First of all, just to refresh our memories, and you may want to remind me of things here, Mr. Fraser, but my list is, we started off, we're going to have the annual monitoring 2019 aggregates documents been submitted, and I'd welcome a note on that from the council, which compares the 2014 and 2019 figures for Berkshire. Then there was the very small point really, but just to confirm whether the scope of the climate energy declaration does extend to plan preparation. Another one I have noted, and I couldn't read it this morning, but it's MPA document on mortar. So it was referred to the Mineral Product Association, the document in which we derive the 80% factory produced figure. And it was referred to yesterday in terms of relating to block work and brickwork and so on. Those were the three from the council which we had already. I've already mentioned Mr. Anstis, who wants to put in his, if he does, his documents which he says were not available, and we can check on that. But he is required to put that in by Friday, week tomorrow. Won't be accepted after that. Program officer knows that. In addition, on the more recent additional information, there's I haven't put the reference down, but an EA document we was talked about this morning. Now, there is a link to it in the plan, so I'm not too worried about that going into the library as there's a link, but it would be helpful. The one we were talking about this morning.
Yes, yeah, I believe it's already up, sir.
Yes. There was a question about how access considerations were taken into account. If on any of these points, but particularly access from this morning, there's any further note the council would like to give me, I will accept it. But equally, I can equally go back to the documents, sustainability appraisal and everything else in the light of all I've heard. So that's an option, really. One point, another one we talked about was the potential to obtain enhancements to landscape and rights of way and achieve the development principles. That was being considered. I'll accept a note on that. And finally, this whole inert fill availability issue, if there's any way of quantifying that, the quantification would be subject to qualification. I do understand, but it is a bit concerning that it's a truism really now that returning to existing levels by the use of fill can be problematic in terms of timing, and I think it has been rightly said that it is a potential criterion for accessibility. So whatever the council can help with me on that. For now, that is all I want. Does that list sound logical and correct to you from what we've been saying, Mr. Fraser?
Yes, so that tallies with my list, save that. I think we had understood the MPA and the 80% point to be something that Grundon were looking into, and I thought they were going to provide something, and then obviously if we feel the need to respond to that, then we will. But
perhaps that's what I beg your pardon. If it's a document on which the council have relied in preparing the plan, well, I mean, there's no harm in me asking for them to put it in. As long as it's in, it doesn't matter where it comes from.
Of course, I mean, we have no problem at all with Grundon providing further information in relation to this. We would reserve the right to respond.
Well,
we may not need to. But
question mark about that.
That's But as to the others, yeah, that your list completely tallies with ours, sir.
Right, let me put a little bracket around that one. This will probably turn into an email from the program officer just to be certain what we're doing.
Yeah.
Now, in terms of how to progress, I don't know yet whether I can, as it were, go straight to main mod. I've got a lot to think about. I'd like, first of all, sorry, I should have said this first. I've given Mr. Anstis a deadline of Friday the 11th. Can the council think in terms of providing these things by Friday the 2nd of February. Sorry, Friday the 18th. I've got it down as 18th. Friday the 18th of February.
Yes.
Is that doable? I mean, you have a bit longer if you like.
We discussed this internally, so if we could ask for just one additional working day, so Monday the 21st, I think that would, given the number of items and the fact that there's going to be, we need to check with a few people who are outside of the immediate team, if you like. So if we could ask till Monday the 21st, then we'll make sure we have something by close of business that day.
There is the midnight oil request.
Exactly.
Yes, that's fine.
Thank you.
It stems from the fact that I'm not myself available to work on this for about a week or more in between now and then.
Yeah.
Then that will give me 2 working weeks, and I promise faithfully to write to the council by Friday the 4th of March, basically to say where I'm up to. Now that could be anything from, this is what I think we should do about main mods, to I want you to do this, that, or the other because I need more information. I hate doing this. I don't want to leave a dedicated planning team in suspended animation wondering what's going to happen, but I don't know myself yet.
Of course. Of course.
Those are the dates. Monday the 22nd, Friday the 4th. And after that, once we get to main mod stage, obviously I'm anticipating the council know the form. They'll be doing a comparable regulation 19 process taking 6 weeks, and then report back to me, by which time I'll have written report in first draft, and it should be delivered quite soon after that in the normal course of events, or in an uninterrupted course of events. That's the best I can do in terms of predicting how the examination will go from now. And I just want to say thank you for the way Mr. Kemp has run things, and also however the IT has worked from the council as well. Those of you who are silent but attending, the whole team. I have to say the way the documentation is presented in this case, including, as I said the other day, the track changes version of the main mods, quite exemplary actually. I think it's quite good to follow. So unless there's anything else, we may not see each other again. You'll probably say, well, we hope not. I don't take it personally if you do. And so that's it from me, and you know what I'm aiming to do. So
can I just, so is it possible for me to just make a quick comment? So thank you for the way you held the inquiry, hearing, shall we say. Can I just say, Stuart for Grundon is going to look at this, where the MPA has given this figure. Would it be permissible for me to provide similar information from other sources, including the MPA, on the 80% figure?
Well, I don't want any further representation. It was just a document.
Yes. I wouldn't make any representations. I could just forward documents that discuss this.
Well, the MPA, Mr. Mitchell will know which document he was referring to, and if he wants to put it in, he can. And if it lands up in the library, fine. But that's as far as I want to take it. So,
okay.
That is anything else? We'll leave it there.
Thank you, sir. I mean, the only thing to say is that just from the council's perspective, we're very grateful to you for the way you run the hearings, and also to Mr. Kemp for such a smooth operation. So thank you very much indeed from our perspective.
Well, it's nice to know we've got a smooth operator running things.
Absolutely.
Right. Thank you, everybody. And
thank you very much.
I'll be in touch. Thank you.
Thank you very much.